So we are recording now. Good evening and Assalamu alaikum, everyone. My name is Ahmet Tekelioglu. I'm the Executive Director at CAIR-Philadelphia. Tonight, we have the honor of doing a webinar with our CAIR-Philadelphia Executive Committee member, Attorney Adam Attia. Adam Attia is an expert education attorney, someone who is well placed to lead tonight's discussion on a recent legislative effort, as well as a broader issue that impacts educational settings both in the secondary and the higher education settings. In the past 8 months, Adam has been instrumental in helping us assist students and parents in the area, whether that's in colleges or high schools, as well as some teachers, to navigate the very difficult terrain that we are experiencing with increased anti-Muslim bias and with increased instances of violation of First Amendment rights. Just briefly to introduce you, Adam is currently an education attorney at Barton Gilman, specializing in representing charter schools, private schools, post-secondary institutions in a wide array of issues that educational institutions face. He has been recognized in different ways through his firm, and previously has also worked at the Pennsylvania Department of Education in Harrisburg, dealing with education law, transactional matters, and serving as assistant counsel to the State Charter School Appeal Board. He got his bachelor's degree from Temple University, and I went on to law school at Thomas Klein School of Law at Drexel University. And while in law school, he completed his co-op internship with the Nationality Service Center, assisting with family-based immigration matters and asylum applications, as well as teaching to high school students as a Marshall Brannon Constitutional Literacy Fellow. He and his wife Sadaka live in the Philadelphia area and are contributors to our communities in different ways. Adam, we appreciate you and the work that you do. And without further ado, I'm going to leave to you to explain to our audience our intention with this webinar, and then I know that you have prepared the presentation to run through the information that we would like to share tonight.
Awesome.
If I may, just right before you start, I apologize, but a few reminders. One is our audience can put their questions under the Q&A button in a written format. If anyone is hesitant to write and would rather want to talk, I think you should be able to use the raise hand segment once we get to our question and answer session after we wrap up Adam's presentation. With that, floor is yours.
Thank you very much for that introduction, Ahmed. Thank you, everybody, for joining this evening. I'm going to talk about House Resolution 6090, its definition of anti-Semitism. Going to go over what the law says, then kind of go into what the problems and what the concerns are with this and the issues that it will cause in the post-secondary and secondary education realm. Before I start and share my screen, I definitely want to give the CAIR staff a shout out for all the work that they've been doing this last year. They've doubled their workload in just a few months, and Brother Ahmet, Timothy, the staff attorney, and Sister Iman, the paralegal, they've been doing a great job, as well as everybody else. All right, I'm going to start the presentation. What is wrong with House Resolution 6090 and the IHRA definition of anti-Semitism? So I'm going to go over the act itself and the resolution. In the sense of Congress section of the resolution, which is basically like the policy behind it, Congress says that Title VI of the Civil Rights Act prohibits discrimination on the basis of color, race, national origin in programs and activities that receive federal financial assistance. Goes on to further state that Title VI does not cover discrimination based solely on religion. However, people who are facing discrimination based on perceived shared ancestry or ethnic characteristics do not lose the protection of Title VI just because they also happen to be members of a group that share a common religion. Go on to say discrimination against Jews may give rise to a violation of Title VI when the discrimination is based on race, color, national origin, which can include discrimination based on actual or perceived shared ancestry and characteristics. We go on to say it's the policy of the United States to enforce Title VI against prohibited forms of discrimination rooted in anti-Semitism as vigorously as it enforces all other forms of discrimination prohibited by Title VI, race, color, and national origin. It references the U.S. national strategy to counter anti-Semitism issued by the White House last year. There's a few key areas: increase awareness and understanding of anti-Semitism, improve safety and security for Jewish communities, reverse the normalization of anti-Semitism and counter anti-Semitic discrimination, and expand communication and collaboration between communities. In the findings section, the resolution states that anti-Semitism is on the rise in the United States and is impacting Jewish students in K-12 schools and universities. The International Holocaust Remembrance Alliance, which is the IHRA, they say that their working definition of anti-Semitism is a vital tool which helps individuals understand and identify the various manifestations of anti-Semitism. It goes on to mention the executive order from 2019, which encourages the use of the IHRA working definition when investigating and enforcing Title VI. Since 2018, the Department of Education has used the IHRA working definition of anti-Semitism when investigating violations of Title VI. It also goes on to say that the use of alternative definitions of anti-Semitism will impair the efforts to combat anti-Semitism, and it may fail to identify many of the modern manifestations of anti-Semitism. And we're going to talk about these modern manifestations of anti-Semitism later on in the presentation. So the resolution and act itself is pretty short, but it says the definition of anti-Semitism it means the definition of anti-Semitism adopted by the IHRA, which the United States is a member of, and which definition has been adopted by the Department of State. It includes the contemporary examples of anti-Semitism identified in the IHRA definition. The contemporary examples of anti-Semitism is what's really being added into the enforcement measures now, and that's creating like the problematic area that will definitely impact our community, and not just our community, but the larger community in general, and will definitely hinder free speech and discussions regarding Israel. So the definition of anti-Semitism by the IHRA states that anti-Semitism is a certain perception of Jews which may be expressed as hatred towards Jews. Rhetorical and physical manifestations of anti-Semitism are directed towards Jewish or non-Jewish individuals and or their property, toward Jewish community institutions and religious facilities. This is the definition that they've been using for several years now. This definition in of itself is not necessarily like what we have concerns with. It's the addition of the contemporary examples on, which I'll show you now on the next slide. So the IHRA list on their website, they had that previous definition, and then they have 11 examples that are contemporary examples of anti-Semitism. I'm going to go through these, but I've highlighted the ones that I find particularly problematic. I think some of these definitely highlight what anti-Semitism is. So they're not highlighted, like specifically calling for, aiding, or justifying the killing or harming of Jews in the name of a radical ideology or an extremist view of religion. I think this one, uh, again, on itself, I think definitely like shows is representative of anti-Semitic attitude or behaviors. Uh, we wouldn't want any groups calling for or justifying the killing of Muslims based on any type of radical ideology, or not just Muslims, but then calling, if this was applied to any of the different groups, race, ethnicity, or national origin, people are advocating for the harming or justifying the killing of people just based on those issues. That would be discrimination. Um, the next example is making mendacious, dehumanizing, demonizing, or stereotypical allegations about Jews, such as the power of Jews as a collective, such as especially, but not exclusively, the myth about a world Jewish conspiracy or of Jews controlling the media, economy, government, or other societal institutions. This has been at play for the past several years with certain celebrities and things like that who have made these statements, and that was targeted as anti-Semitism. Yeah, this one could be highlighted, but I think that's something that's kind of been ingrained into our society as like kind of under the public generally like thinks these statements are anti-Semitism. The next one is accusing Jews as a people of being responsible for real or imagined wrongdoing committed by a single Jewish person or group, or even for acts committed by non-Jews. So again, didn't highlight this as like problematic because I try to kind of reverse the situation and see what it would be if it was applied to Muslims. And I know one of the major concerns that like Muslims and the Muslim community has is that when a terrorist group or some Muslim dictator or government, operates in a certain manner, people want to assume that all Muslims would act in that manner. And that's something that like we identify as Islamophobia. So I think accusing any individual of any type of group, whether it's race, religion, national origin, or color, holding them responsible for crimes or actions committed by someone of the same group, that's something that is discrimination. This next one, I probably should have highlighted it just based off of like free speech concerns, but denying the fact, scope, or mechanisms or intentionality of the genocide of the Jewish people at the hands of the National Socialist Germany and its supporters and accomplices during World War II, the Holocaust. This is something that's definitely frowned upon in society, and has been, for a long time. However, in America, with the freedom of speech that we're given by the First Amendment, we're generally allowed to like criticize or question things. Where throughout European history, any kind of discussion related to the Holocaust or questioning the extent of the Holocaust, people have faced criminal charges over that, or they've faced legal ramifications, where that has never been the case here in the United States. Adding this to the definition, now it doesn't bring about criminal charges against anybody, but there are legal ramifications for any kind of discussions that would question the scope or mechanisms or intentionality of the genocide during the Holocaust. The next one, accusing the Jews as a people or Israel as a state of inventing or exaggerating the Holocaust. Now, this one specifically ties in Israel and the actions of Israel as a state. So saying Israel is exaggerating the Holocaust would be deemed anti-Semitic. So these next ones, though, I've highlighted because they really shift what the current landscape is with the dialogue regarding Israel, and really ties it into anti-Semitism, which could have legal ramifications for schools, and then in turn, like all the students in schools who say these things, or student groups who say these things. accusing Jewish citizens of being more loyal to Israel or to the alleged priority of Jews worldwide rather than to the interests of their own nations. Now, I think saying that Jewish people are more loyal to Israel on its face is anti-Semitic. However, this has come up in certain situations about particular individuals who happen to be Jewish. Just for example, like Ben Shapiro. In the circles that he runs in the conservative movement, there are people questioning his loyalties and stuff based off of like his opinions, but that now would be deemed anti-Semitic, based off of this contemporary example of anti-Semitism. The next one is denying the Jewish people their right to self-determination. Example, by claiming that the existence of the state of Israel is a racist endeavor. This one I highlighted as problematic because, again, it ties in specifically the state of Israel with anti-Semitism, and it's drafted broadly. So to deny Jewish people their right to self-determination, where there could be discourse regarding how the state of Israel was founded, the European influence behind the foundation of the state of Israel. But even those discussions are now deemed anti-Semitic. So can't talk about those in school if this gets passed by the Senate, which hopefully it doesn't, but it could happen. The next one, applying double standards by requiring of Israel a behavior not expected or demanded of any other democratic nation. This one is problematic on several fronts. First of all, it's very vague. So, what exactly does it mean? I'm not sure. I don't think anybody would know for sure, especially to the people who are tasked with trying to determine whether something's a double standard or not a double standard. It also ignores the facts of Israel and Palestine. It ignores like the facts of foundation of the state. It ignores that unlike other democratic nations, Palestinians were displaced. They are subject to different laws. So it really ignores the facts on the ground and saying that, well, if you don't require other democratic nations the same thing, then that's anti-Semitic. Next one, using the symbols and images associated with classic anti-Semitism. Example, claims of Jews killing Jesus or blood libel to characterize Israel or Israelis. Historically, blood libel has been a thing throughout history that has been used to target and slander Jewish people, and it is a form of discrimination. Now, in the present context, though, this could hinder any discussions or any dialogue regarding the number of children who've been killed in Gaza, over the past 7 months, where people are trying to tie any claims or any tying in of talking about the dead children in Gaza as blood libel, where just even historically, we haven't seen this many children killed in this short amount of time in like any of the modern wars. So this will definitely hinder free speech. Now, I know also there's a few conservative representatives who didn't vote for this act to pass because they are saying that the claims of Jews killing Jesus conflict with their religious beliefs. Now, that's not an argument that I'm here to make, but it does show that there are people on from different backgrounds who do view this definition differently. The next example is drawing comparisons of contemporary Israeli policy to that of the Nazis. So any correlation between what Israel's doing and Nazi Germany would be deemed anti-Semitic. That's something that there has been at protests or various discussions and things like that, there have been comparisons to Nazi Germany, and it doesn't necessarily mean it's at the same extent or the same scope or the same numbers, but even to make comparisons or to have the dialogue to discuss whether it's appropriate or not appropriate. This comparison, just having these conversations itself is deemed anti-Semitic. And then the last one I didn't highlight, even though it does tie in the state of Israel, but is holding Jews collectively responsible for actions of the state of Israel. I didn't highlight it because, again, as Muslims, I think we're very well aware that holding Muslims collectively responsible for the actions of any particular group or country is Islamophobic, and it's something that we've been trying to fight against for a long time. So these are the contemporary examples of anti-Semitism, and these are the new additions that the Department of Education has to take into consideration when they are investigating any type of Title VI complaint of anti-Semitism. I think you can probably see why there's concern regarding this, and that a lot of these are vague, and it's going to hinder free speech across the country almost at all levels. So why are the contemporary examples problematic? Again, some seem to be examples of anti-Semitism, and putting it reversing it if it was Islam and stuff like that instead of anti-Semitism, or we wouldn't want people to be doing the same thing against us, and if they did, we would want that to be deemed Islamophobic. So, calling for the killing or harming of Jews in the name of a radical ideology, I think that shows that is anti-Semitic attitude, that is anti-Semitic behavior. On the other hand, applying the double standards by requiring of Israel behavior that's not expected or demanded of any other democratic nation, I don't know how on the face that would be anti-Semitic. I'm sure in those kinds of discussions, it could lend itself at times to people saying things that are anti-Semitic, but just that definition on its face, you could want to hold Israel to a higher standard for, numerous reasons other than some kind of discrimination against Jews. It also, would hinder and prohibit dialogue regarding political and humanitarian concerns about Israeli action and policies if people don't demand specifically the same thing out of America or France or Germany. But it ignores that America or France or Germany weren't founded, by resolutions at the United Nations. They didn't displace, I'm not going to say they didn't because they have displaced, but the facts on the ground currently are different than Israel and Palestine. So these are some of the reasons why it's problematic. Again, 7 of the 11 definitions specifically tie in Israel and any criticism of it with anti-Semitism. Another reason this is problematic is this ignores the thousands of Jewish Americans who stand against Israeli policies and actions and who have really been at the front lines of protesting the war. It would prohibit the statements and sentiments of organizations like Jewish Voices for Peace and a lot of the students. It also really conflates and ties Israel is Judaism. Judaism is Israel. And there are many Jewish organizations, Jewish professors who've really come out against this, and especially because it politicizes the term of anti-Semitism to meet the current events going on in the world. But making it anti-Semitism and the definition of it political could hinder the efforts to actually try to combat true anti-Semitism that is occurring. Something too that's problematic about this is it doesn't mention, some of the worst attacks have against Jewish people in modern times in the United States have been committed by white supremacists. And this definition doesn't do anything to talk about those kind of sentiments. Rather, instead of addressing that at all, it kind of tries to, make the definition of anti-Semitism revolve around your political opinions of the Israeli-Palestinian conflict and the ongoing war. And then the other reasons, in the law, anything that's vague is very hard to follow. Laws sometimes are struck down for being overly vague. So a lot of these examples are vague, which will lead to unclarity as to what is considered anti-Semitism. And then also with this is going to require educators, school administrators all across the country to have like an expert level knowledge of what anti-Semitism is, an expert level knowledge of the Israeli-Palestinian conflict going on. So it's something that is going to require an extra burden on schools and require schools and educators to really, I don't know, it's going to hold them to a higher level than they have to be right now. So that's something that whenever you require more out of these educators, they're going to have to, they're like, most likely their instincts are going to be just to shut down the conversation completely. So like everyone would have to become Middle East politics expert, which people get paid a lot of money to talk about this and spend years studying it. And now that's going to be expected like across the board for all educators. So what is Title VI? Title VI specifically prohibits discrimination on the basis of race, color, and national origin in programs and activities that receive federal financial assistance. It does not, again, specifically prohibit discrimination on the basis of religion, but based off of the case law and precedent, sometimes religious discrimination blends into race, color, and national origin. And also for claims of Islamophobia, sometimes, right, Islamophobia is not covered under Title VI, but sometimes, successful like complaints of Islamophobia are found because even though it's not directly on point with Islam, it does tie in with individuals' national origin, their race, or their color. The U.S. Department of Education, their Office of Civil Rights investigates claims of discrimination under Title VI. They'll receive students, parents, community organizations can submit complaints. If on its face they deem that like it's there could be some kind of form of discrimination, they conduct investigations. If they find that there is discrimination going on at schools, they'll usually require schools to sign a resolution with certain actions that the schools have to take in order to prevent this type of discrimination from occurring. If the schools fail to listen to the resolutions that the U.S. Department of Education makes them enter into, then they could lose all federal funding. Now, this is a problem because most schools across the country receive federal funding in some way or form, and many schools like rely on federal funding. So I'm just going to talk real quick about free speech under the First Amendment and how it applies to schools. Generally, freedom of speech is the right to express yourself publicly without the government interfering. That's not the exact text of the First Amendment, but that's generally what free speech is. Now, a key word in that is without the government interfering. Lots of times, like private employers can interfere. Individuals in the general public, they can interfere with your free speech rights, but the government can't pass laws and the government can't take actions in order to hinder individuals' freedom of speech. Now, there are many caveats and they've kind of narrowed it down, but students at public school have the right to free speech. Famous court cases, they say the right to freedom of speech doesn't stop, once you enter the school grounds. like as a student at a public school, you have the right to free speech. Now, through case law, school officials can limit your free speech if it's deemed to substantially and materially interfere with the work of the school. This came about like with protests of the Vietnam War. Students were wearing black armbands to symbolize their opposition to the Vietnam War. The school banned them from wearing them. The Supreme Court ended up ruling that these students, they're allowed to wear the black armband to show that they are opposing, the Vietnam War, and that a school can't interfere with their free speech rights just because the school disagrees with it or it's controversial. Now, if the activities or the free speech that the students are expressing ends up substantially and materially interfering with the work of the school, that's when they can limit it. But generally, students' free speech rights are the greatest that they will be at public schools and universities, because the public schools and universities are considered state actors. They're part of the government. So it goes back to, the first point on here is that you have the right to express yourself publicly without the government interfering. So when the school is the government, they are very limited in how they can limit a student's free speech rights. Now, at private schools and universities, and similar to like private employers and things like that, but starting specifically with the private schools and universities, students, they generally have the right to free speech, but it's as a matter of contract law. The student enrolls, they're paying tuition, and all these schools, they have handbooks and policies. And many of these handbooks and policies say students have the right to free speech. So students don't have free speech rights at these private schools just based off of the First Amendment. It's based off of a contract between them and the school. They pay to go to the school because the school allows them to have these free speech, these rights to free speech. And schools include those in their policies and handbooks. To educational institutions, they are generally supportive of the First Amendment, and also schools that don't have these policies, theoretically students wouldn't want to attend these schools if they don't have free speech rights. But again, with any cases that come up, this is something that you really have to analyze and think, and even for the students and student groups to consider, is at a public school, you're going to have more leeway with what you can say, what you can do, because the public schools are state actors, so they really can't interfere with your rights unless it's causing the free speech is causing a substantial or material interruption with the school, the work of the school. At private and also at public schools, you have due process rights in order to get to, if you're facing disciplinary measures, generally you have a right to an attorney. It's the government, so you have these due process rights. At private school, you don't necessarily have these due process rights. You have whatever their handbook says, and lots of times they might allow you to have a representative from the school community be there with you, but generally you're not entitled to have an attorney. The schools can just say, "Oh, you violated the handbook, so you're being disciplined." Now, so with the free speech, considerations and this new HR 6090, any educational institution that receives federal funding is at risk of losing the federal funding if it does not prohibit the conduct or statements that were listed in the contemporary examples of anti-Semitism. This will if this passes, this will no doubt have a major chilling effect on free speech and any discussions or criticisms related to Israeli policy. 7 of the 11 definitions specifically name Israel in the examples. And again, because schools risk losing federal funding, they're going to be overly cautious with interpreting the contemporary examples of anti-Semitism. they'll likely try to shut down any discussion or criticism of Israel, especially if they think it's a gray area. We're not sure if if the end result is losing all federal funding, they're going to definitely be more on the cautious side and just try to shut down any conversations. Again, this is problematic too because it's requiring school administrators to become Middle East political experts and to really hash out, well, is this just political or is this anti-Semitism? And once you start having that conversation, they're just going to side with, we don't want this, and it's going to really shut down any kind of criticisms of Israel. Again, so Title VI, like most schools receive Title VI funding, private schools and public schools. So this kind of goes beyond just the free speech arguments, said a few minutes ago between the public and private schools, where this will affect almost all the schools because they all receive federal funding. There's a few colleges that don't receive federal funding, and they do it because they, not that they want to discriminate, but that they have their own ideology and they don't want any interference with their ideology, so they don't accept federal funding so that they can teach what they want to teach. And lots of times this is religious institutions. But again, most like Catholic universities and Christian universities in the country, they do receive federal funding. So this is something that's going to impact like almost every student and will impact every college. All school districts across the country receive federal funding. So this is something that's really going to impact like all, aspects of the education field. Why is House Resolution 6090 wrong? First of all, free speech considerations. Many organizations like the ACLU, they've come out against this based off of the freedom of speech implications, and that it will just have a chilling effect on being able to express any kind of opinions, regardless of whether it's about Israel or not. The laws are vague, and these organizations, they think, they believe in the First Amendment. They want like the First Amendment to be exerted to its fullest. And this definition in HR 6090 definitely like hinders that. Again, many Jewish organizations and professors have spoken out against HR 6090 because it really conflates Judaism with Israel as a nation. And with that, they've said that this will hinder efforts to combat actual anti-Semitism that is occurring and is rising across the world. And they said that it could also possibly, based off of the politicization of the definition, it could possibly like create more anti-Semitism against Jewish students and doesn't really do what its goal is, if the goal is to, combat and prevent anti-Semitism. School entities will likely shut down any kind of dialogue around Israel because it would subject them to an OCR investigation and ultimately, worst case, a loss of all federal funding. Another thing that's really, problematic about this is in order to change it, you will need a court, either an appeals court or the Supreme Court, to deem that this is unconstitutional. So in order for that to happen, that means it has to go into effect. That means students will be punished or free speech will be hindered up until a point where it goes through the legal system and a court of appeals or the Supreme Court says, no, this is unconstitutional. And that can take years for that process to play out. So, and also with the circuit court, there's a possibility that maybe in certain parts of the country, you can say certain things and they say, oh, this is not anti-Semitic, but other parts of the country say, oh no, like you can't say these things. It is anti-Semitic. So it is going to have to be a long, drawn out legal battle in order to like see where it finally stands. And I believe that's all I have with the presentation.
Yeah. Thank you so much, Adam, for this. This was a fascinating journey into this. Just again, a reminder for everyone to post their questions in the Q&A segment, or if you would like to speak and ask, I can allow you to do that. Just maybe a few things to add from my side. Where does HR 6090 stand currently? It hasn't yet come to the Senate. The other thing to note, and as our in Pennsylvania phone bank volunteer leads are with us in the House, we saw unfortunately only 3 Pennsylvania House members vote no against this. This was Dwight Evans, Mary Gay Scanlon, and Representative Lee. 1 Republican, Thompson, didn't vote. But the rest of the congressional team voted yes in response to this resolution, with some trying to explain their votes by saying while they disagreed with certain aspects of it, they didn't want to not take a stance against anti-Semitism, which was a very weak argument, given that constitutionally these lawmakers essentially have put their constituents at risk, and we are working to make sure that this doesn't come to the Senate and then passes and actually becomes a law. The second thing maybe to add, both in regards to our work at CAIR-Philadelphia, is that we are raising awareness around the problems with the IHRA definition, the IHRA definition, as there are other definitions of anti-Semitism that is used, like the Jerusalem Declaration on Anti-Semitism and the definition that it brings, which doesn't include the same kinds of issues that the IHRA definition has. While anti-Semitism is a real problem and an issue, it at the same time cannot be defeated by making freedom of speech more restrictive. There are a few other things that we can discuss here, but especially I want to highlight that we anticipate a similar effort towards legislating IHRA definition into law might be coming up in Pennsylvania, and we hope that many of you will work with us, and we'll work in coalition with all of you to stand against such a move in the coming weeks. One question from Sir Nusrat Roshni, Adam, in the Q&A is, if HR 6090 does pass, what would be our next action to add pressure to continue opposing it?
Oh, that's a good question. I don't want to say once it's passed, it's too late. You can continue to put political pressure on the same people who just passed it to reverse it. They can change the law, but with once it is passed and it does go in, the Department of Education is legally required to use that definition when they investigate anti-Semitism. I think you're going to have to put political pressure on Congress to change it, or you would really have to mobilize efforts and not kind of test cases. We would have to find a specific example where they are hindering free speech, where we think there's no way that the courts will deem this to be anti-Semitism, that this is purely just criticism of Israel. And we'd really have to make the strongest legal arguments, get the brightest legal minds behind those kinds of efforts, and have those cases go up. There'll probably be a lot of cases that would probably lose on going up, but we would have to find the right case that highlights kind of the issues with this and really conflating Israel with anti-Semitism, and we'd have to put all our legal efforts and political efforts behind that.
Mm-hmm. So to just explore that, there could be a Supreme Court case or a lower court case that sort of argues that this law essentially has curbed someone's basic constitutional freedoms. and hence should be struck, is that and such a decision could potentially then lead the Department of Education to consider that in its own decision making. Is that correct?
Yes.
In the absence of another law that's now sort of like, amends any harm that could be done.
Yeah.
Okay, thank you. I appreciate that.
This question, I find, saying ceasefire, will that also be considered anti-Semitic according to this? And I think, that's up in the air. Whether they could make the argument that were we calling for a ceasefire when America was at war in Iraq? Did we call for, Germany to cease fire with the war in Iraq? Did we call for America to cease fire when they were attacking ISIS? So under the one example that they provided, it could be deemed anti-Semitic if we didn't require or don't require the same thing of other democratic nations. And I think that really, just that statement, ceasefire, really shows why this is problematic.
So, Rabia, thank you for that question. And it shows, like, how dangerous this sort of like vaguely defined language in definitions are. I think, like, one of the important points is that in its anti-Semitism summit last summer, the White House did make references to the IHRA definition, but didn't officially adopt it as a definition. So there is differences between IHRA definition being used as a reference point, and there are aspects of it that different organizations will do, but codifying it into law definitely brings another weight and gives it another force, and hence makes the examples and the limited sort of structures that the examples impose more problematic. So likely there will be ongoing references to it. With that, maybe I can interject with a question, Adam. Some school districts in the last 6-7 months have adopted the definition themselves. What does a school district adopting the IHRA definition mean, and how would that be operationalized?
So when the school district adopts, their policies, like they're run by school boards that have rules and regulations, then they're required to follow those policies. So if they're not following those policies, they're breaking, their own rules. I think going forward, whether this passes the Senate or not, I think there will be a lot of school districts that use this definition, especially because it's called the Anti-Semitism Awareness Act. No one, right, wants to be standing against combating anti-Semitism, so they're going to try to adopt these and implement them. I think how you combat that at the school board level is, public comments, trying to get them to change their opinions, voting for school board members, or putting influence on people who have the authority to appoint school board members, really emphasizing the problems with the IHRA definition and the contemporary examples. But they pass it themselves, they have to listen to it. But I do think that many will start to just pass this regardless of whether it gets passed in the Senate or not. And I think this is something too, that there's a legal way to go about things, but lots of times things are influenced, politically and through like PR, and there's going to have to be a lot of that. I think, CAIR does a great job with that already. But that's something kind of that I don't really have the expertise about, with like the political organizing and really trying to like be in touch with representatives.
Yeah.
Yeah. So, yeah.
Yeah, we'll definitely be like, and based on like a specific area, the specific need, we would be building a campaign around that. There's another question in the chat from Brother Mohammed Zubeiru. Is there a way to counter the chilling effect that just this conversation has created?
It's politically right now. That's the way we have to counter it. We have to like really make sure that it doesn't get passed by the Senate, because then, any student, any parent, anybody can complain saying, "Oh, well, this was said in class. They don't require this of other democratic nations," and submit the complaint, to the Department of Education, and they're going to have to investigate it specifically using that example. That's going to be in like a checklist of things that they go through during their investigation. Like, well, and then, um, so I think the way to counter it is really politically, hopefully that it doesn't get passed. But then if it does get passed, to like continue uh, political efforts, voting in representatives who would oppose this or like vow to change it, working with the current representatives to explain why it's problematic. Um, so I think this is something that it's a very like serious problem that will definitely um, have big impacts like across the board for our community. Um, and it's a shame because they've already. I feel like our community is very well versed in having these kinds of dialogues. I know like at sometimes at protests, there's certain people saying things that it's not what the general community believes or thinks, but I think you know CAIR and other Muslim organizations, they've done a great job over the years, like working with the Jewish community and trying to combat anti-Semitism, even representing, Jewish students. This is like ironic with all of this too, is with our work, there's a lot of like Jewish students who CAIR is assisting or helping out or has helped out. And these Jewish students would be targeted for being anti-Semitic. Um, but it's going to be a political effort like across the board, and we're going to have to, if it does pass, continue like putting pressure on anybody who has like decision making authority, and again across all the school boards across the country, like really continuing this pressure so that the individual school boards themselves don't pass it. And then there's also the option of like, or the possibility that Pennsylvania, passes it, and then that could be tied in with like the work that the PHRC does or things like that. So even if like the Senate doesn't pass it, various states may pass something similar. So I think it's something we're just gonna have to like really politically fight and put pressure.
Something. Thank you for that. I think we have one more question from Mr. Rabia. What are the chances that this will get passed? Mr. Rabia, the reading currently in Washington, D.C. about the chances of this coming to the Senate and then passing there is relatively low currently, but we are continuing to monitor it based on like how the political climate and the winds change. It's definitely a danger and a threat for our communities. There are several other efforts like the one bill that is trying to problematize the nonprofits, also like bring more restrictions to nonprofits. That has a little bit more legs currently in DC. But HR 6090 currently on the Senate side, we are hopeful that there will be it won't come to the floor and that there will be some reaction to it. Having said that, our own senators in discussions last week by community members are not giving us the most hope and courage to say that they may be they may be taking a principled stance against this. It is more so currently in the calculations across the House and the Senate side that whether this would come to the floor or not. We're hopeful that the reactions from national groups, our communities, ACLU and others will help the majority to not bring it to the floor for a vote. But efforts are ongoing. Definitely pressure on Senators Casey and Fetterman, as small as the chances of them taking a proper stance on this appear is important and should be ongoing.
I do think working with like Jewish organizations who are standing against this as well, it's a lot of Jewish organizations and academics and professors are like really worried about the implication of this, just not just for free speech considerations, but for also like the safety of Jewish students, because it really politicizes the issue. Um, and I find it hard to like disregard, a Jewish organization saying that like this is like threatening to our community, and then politicians are saying like, no, you're wrong. So it doesn't make much sense.
Yeah. All right. Are there any other questions and once and twice? I think Adam, perhaps like what we can tell our community is that an effort on this in a more proactive manner, educating our state senators and state reps about why the IHRA definition being codified into law is problematic and should not be considered, will be ongoing. We'll hope to build out a project around this in the coming months, and we are monitoring Harrisburg to make sure that something like this doesn't try to be squeezed into sort of lines during the budget discussions through June. There are allies who are also watching out for this with us, but that our community should be on the on sort of like on ready to go mode in case we need any fast mobilization on this. In the meantime, we encourage everyone to have conversations with their elected officials about this. If anyone would like to have maybe access to the slides, Adam, we can maybe consider emailing that to you. So please feel free to reach out on that. But with that, we want to thank you for your time and expertise on this and for everything that you are doing for CAIR-Philadelphia. We want to thank everyone who joined us, who intended to join us as well. Maybe one final question that I see, I think it would be this is an important question from Sarabia. People who are posting videos on social media will also land into trouble if this passes. Is a question.
That's a good question. This under the law, schools can criminalize, or they can discipline actions that occur off school campuses. But it has to, again, substantially and materially interfere with the school's work. So if there's a student group posting on their social media or members of a student group posting on their social media and it's causing an uproar in the schools and things like that, the school doesn't do anything and a parent or a student complains, there is a possibility, with also how vague the definition is, that the Department of Education could say the school's not taking the correct measures, to ensure anti-Semitism is not occurring at the school. Now, social media posts are like a very tricky issue just in general, but there is a way that it can get tied in to this whole conversation if it is causing disruption at school. So that's a really good question.
Yeah. And it shows the extent to which, there can be this nebulous, like not well-defined, open to interpretation, chilling impacts that might exist. Right, with that note of caution for all of us to be mindful, and then why our civil rights and the fight against such restrictive bills is important. We want to thank everyone for joining us and for their time. We look forward to being in touch with you all. Thank you so much, and thank you again, Adam.
Thank you, everybody. Thank you, Ahmed. Appreciate it.
Thank you. Have a good night.
Yeah, Assalamu alaikum.
Salam. Thanks so much.